Hello, this is Jim Fitzgerald, the Marshfield Town Moderator, and we're doing a brief meeting today with Mike Maresco, Town Administrator, and Robert Galvin, who's the Town Council, about the special town meeting for Monday, December 16th. So to start off, I'm just going to go down the list of articles. We're going to have a brief discussion as needed along the way from my cohorts here, and get you a little more information on what's on the agenda for Monday's meeting. So it's a big warrant. There's 28 articles in the warrant. We do have a few changes along the way with at least one passed over article, and I think maybe two at this point. But there's a lot on the agenda, and one very important article on new zoning to comply with the state's MBTA housing initiative that is going to be a hot button issue for town meeting. So without any further ado, Article 1 is an annual article, or twice a year. We do it in the spring, we do it in the fall, about paying unpaid bills. And it's a fairly long article here. It totals up to $129,121. And these are bills that were submitted after the closing of the warrant at the end of, or at the end of the fiscal year. So these need to be paid, and the way they need to get paid so that they go into last year's annual budget is to have them approved as overdue bills. So you want to add anything to that, Mike?
Yes, I may, Mr. Moderator, yeah. So people, they're usually used to coming to town meeting and seeing maybe a dozen of these bills. We have a new accountant, a new treasurer. They went through everything line by line, and folks will see there are some bills that go back to 18 and 16 that were never paid, and the vendors have been sending us nasty letters. We were able to, the new treasurer and the new town accountant were able to prove that we never actually paid those bills, so those are money owed. And then we have a very strict process. You know, department heads are required to get a quote. They're required to encumber the money by a rec system. If it requires a contract, they have to get the contract. We have to have an invoice, and then we do payment. So these particular items that are before town meeting to approve, we have the money to pay them. We just need legally the authorization of town meeting because they're at the end beyond the fiscal year.
Yep. This is one unusual article from a just kind of inside town meeting type of thing where it's got to be a 9/10 vote. It's one of the few articles where we need a supermajority to get this thing passed. But that's just one of those things that always kind of rises to the level of notification for me because of that. Article 2 is ratifying some collective bargaining agreements with the clerical union and the supervisory union. Mr. Maresco?
Yes, Mr. Moderator. So we've been going through all of our contracts ended, and over the last year and a half, we've been renegotiating with all of our unions. This will almost close out all our negotiations. We're very close with settling with our fire department. We hope to have that settled before the end of the fiscal year, before the end of the calendar year, pardon me. But right now, we're putting before town meeting the clerical and supervisory, and their increases are funded within the budgetary dollars that we have. That's why there's no dollars affixed to it, and we always bring it to town meeting to
Right.
support the select board.
So there's no financial implication to the town.
That is
as far as
correct.
that goes. Article 3 is a personnel bylaw, and basically what this does is changes the payment structure on each grade of the employees that are not within a union to be, so that those wages are commensurate with what the union wages are, so it's sort of a level playing ground.
Mr. Moderator, you did a great job. We do that every year just to be fair to our bylaw employees.
Okay, Article 4 is a capital budget article, and this is, a lot of this is coming from free cash, some of it's from wastewater retained earnings, and the solid waste retains earnings. There are requests from pretty much every department. It totals up to be $2,552,301, and there's police, facilities, town clerk, fire, schools, DPW, Facilities, Rec Trails, Harbor Master, IT, and Cultural Council all have requests on this warrant. I suggest you go to the town website to take a look at the warrant so you can see the details of what's being requested. Rather than go through all that now and read them. But it's a fairly straightforward type of article for us when we get free cash certified. And this won't affect the budget because it's all coming out of free cash.
That is correct, Mr. Moderator. And if I may, there is one item that we took out, which is item number 8 in the warrant. Item number 8 was for the architect to prepare RFP documents for the restoration of the school roofs.
Okay.
So since later on in the program, the select board voted to indefinitely postpone Article 5, went to the hearing with the advisory board, we decided not to go through with the requesting the funding at this time for that.
Okay. So that's down $93,000, so it's, 2.54 instead of 2.55 million. Article 5, as Mr. Maresco just said, was one that was looking at solar power on the school roofs. That article has been indefinitely postponed, so that will not be going forward at this time. Article 6 is from the school department. It's a new school roof on Martinson Elementary School. They're going through the Massachusetts School Building Authority for a loan from that. So this is a first article on that. They're looking to get that set up and going forward on a new school roof for Martinson that is in need of repair. Anything on that, or?
Mr. Chairman, so Marshfield was very fortunate to be selected in the MSBA's Accelerated Repair Program, and the MSBA will fund somewhere between 45 and 55% of the cost of the roof. This money that's been approved is based on a $7 million estimated cost. The rule of thumb is about 15%. We got that from the MSBA. That's how we got to the figure of $1,050,000, and that's to prepare a schematic design. So then that will better refine what the actual cost will be.
Okay, thank you. Article 7, I think the synopsis on this, which is in the warrant, is a good way to explain it. The town utilizes this regulation to restrict the consumption of alcoholic beverages on public ways and on public property. The town has authorized the issuance of one-day special licenses under Mass General Law, Chapter 138, Section 14 in the past on townways, properties, and properties leased by the town to other entities for community events, block parties, weddings, reunions, village and neighborhood festivals, activities, and events. During the summer of 2024, the conflict between this bylaw and the long-term practices of the town became apparent where events were proposed or occurred on town properties, and in order to continue to allow and support the ability to approve events, a change in the bylaws recommended that we would be consistent with the practice and procedures in other South Shore communities. I think I'm going to go to Mr. Galvin for a brief explanation on that.
Sure. We have a bylaw that probably dates back to the time when the Commonwealth had blue laws and the town had blue laws, where alcohol use was limited and restricted. This article basically restricted people from consuming alcohol on any public property. And what we've done over the years is we've issued one-day liquor licenses for property, including town properties, to have special events. This would include properties like the Winslow House, the Webster Estate. It even includes properties like the North River Arts Society building. It includes the disabled veterans property down in Brant Rock. And what we've tried to do here is recognize that there are certain events that occur on town properties where alcohol may be completely acceptable, so as to not have a conflict with state law and local law. This proposed change would allow the select board to issue a liquor license authorizing events like that to occur on town properties. And the issue that brought it to the forefront was the Lobster Fest this past year. People made an issue of whether the town pier could be licensed to an entity that intended to serve alcohol via a one-day license. I did an examination of all of the town bylaws in all of the adjoining towns, including Situate, Duxbury, Pembroke, Plymouth, and observed that most towns authorize the issuance by the select board of a one-day liquor license so that alcohol could occur under a controlled setting of a special event, including on town properties. So this change is made to authorize that to occur. It doesn't mean it will occur. It just means that it's possible for those things to occur. And I noticed that the town of Situate, observing what we were doing, made the same change because during their heritage days, they allow a beer garden to be set up down on their town pier. And in order to lawfully have that occur without the same issue, they've made this amendment, and that amendment's already been approved in Situate.
Okay.
So this is the reality. You're not supposed to drink on the beach, you're not supposed to drink on public ways, you're not supposed to drink on public properties. But if it's done in the confines of event where there's a caterer and somebody that's responsible providing insurance, the select board would then have the discretion to allow it.
Okay. Jim, anything you want to add?
I just wanted to ask town council, because this just came up this morning in a call, would for-profit businesses be able to apply for a license if they're doing an event at a public building or a public outside facility?
Yes.
Okay, that question came.
They might be limited to what they could
They
sell,
can sell, right,
but
But it is, okay.
a for-profit entity could do it
yes,
as well.
great, thank you.
Okay. Article 8, will the town vote to amend Marshfield Town Code, Division 2, General Bylaws, Chapter 180, Peace and Good Order, by adding a new Article 7, Park and Playground Construction and Reconstruction, as follows. The bylaw, basically, this bylaw change will require all new or existing parks and playgrounds in the town of Marshfield to be constructed or reconstructed in a manner that meets or exceeds any federal and or state accessibility laws and regulations, including the Americans with Disabilities Act, the state public accommodation laws, and the rules and regulations of the Architectural Access Board. So I don't know who wants to take that one.
I'll
Michael?
jump. So I put this together with the help of town council. This was to, a situation came up where Sean Patterson from the DPW had approached me and said he was hearing that some of our parks and playgrounds don't meet certain standards. And he had a company that he worked with down in Bourne when he was the superintendent of the DPW down there. He wanted to bring that person in. What's interesting is the parks and playgrounds are not regulated by state laws or regulations. It's by an association. I think it's the ACTS or something like that. So we brought in this company that happens to be based in Marshfield to inspect all of our playgrounds, and there are numerous issues, the bulk of them being ADA issues, anywhere from not having the proper width of the pathways, not having a pathway around the circumference of the particular park, not having pathways up to each of the activities there. The chain link fence didn't have the small, you have to have the specialty chain link fence with the small so kids can't climb. You can't have any inclusion of like a big stone coming out of the ground, all those types of things. So I was surprised that there were so many ADA issues. We're in the process now of correcting all those DPW work to make sure that we got the playgrounds up and running. The ADA issues we still have to correct. And it's right now we applied for a grant. I asked the DPW to co-sponsor with me a request from CPC for $750,000 to begin to address the ADA issues. So we're going to move forward. But this bylaw, we hope that the town will support, because any of our parks or playgrounds that we have now, any work being done, we have to make sure that they meet all the state, the association's requirements. And any future parks that will be built or will be created, we want to make sure that we don't run into this problem again.
I'm surprised it's not regulated by ADA. That's kind of an odd thing, that there'd be a separate entity looking at the accessibility issues.
The ADA has rules of what they say, but as far as there's no they have their law, but there's no one going out and enforcing it. It falls to Andrew Stewart and to the DPW to make sure.
We've had this issue from time to time on our trails and paths, and we've had to explain the circumstances to the Architectural Access Board. So this bylaw basically solves that by saying that when we reconstruct or we do these playgrounds, we'll make them handicap accessible.
Yeah. Article 9, will the town vote to authorize the Select Board to declare available for disposition a certain parcel of town-owned land located at 1929 Main Street in Marshfield, also identified on the Marshfield Assessors Map as parcel D18-02-05, containing .8 acres of land, more or less, for affordable housing purposes, and further, to authorize the Select Board to dispose of said parcel by sale, conveyance, or otherwise, under such terms as the town may specify consistent with the applicable legal requirements, or to take any action relative thereto.
So, Mr. Moderator, so this, we purchased the McCleary property with CPC funding, signed off by the Open Space Committee. When we did that, a portion of the land, this particular parcel, about .8 acres of land, was set aside to build 1 or 2 affordable units. The original homestead is part of that. It's the, if you drive down 3A, you'll see it, 1929 Main Street. And the Marshfield Marshfield Affordable Trust wants to partner with Habitat. So, we notified the Select Board. We have the article, town meeting, if they authorize the Select Board to declare, because this land right now is under the Select Board, then the trust can partner with Habitat to build 1 or 2 affordable units on that particular parcel.
Okay. Article 10. This is a CPC article. Will the Community Preservation Committee and the Open Space Committee, pursuant to the applicable provisions of Mass General Law, Chapter 44B, to appropriate the sum of $228,900 from Community Preservation Fund Open Space Reserves to fund design, permitting, engineering, permitting, and the preparation of cost estimates for future construction needed to expand the South River Park to include a certain parcel of vacant town-owned land located at 2160 Ocean Street. And that's basically an expansion of South River Park. Correct.
That is correct. Yes, it is. And they want to move forward. This was another valuable piece of land that the Open Space Committee had prioritized as a piece of land that they wanted. It gives access to the South River, which we don't have a lot of access to. And the original purchase of that land was supported by Community Preservation Grant. And this now is the next step. This is to hire the qualified landscape designer to prepare a plan, and then they would then reapply to CPC for the additional funding to make the park accessible for folks to go
Yep.
there.
Okay. Article 11. Will the town vote to act upon the recommendation of the Community Preservation Committee and the Open Space Committee to appropriate the sum of $50,000 from CPC open space reserves for unknown owner title searches and take any action relative thereto?
I'd be happy to explain this. So this article is intended to try to identify owners or persons having a legal interest in properties that we don't know who actually owns them and are identified in our town database as being owners unknown. The ultimate goal would be to see if we could identify people that could potentially sell or have the land donated to us for further open space expansion. And this estimate is arrived at by getting a rough estimate from a title examiner as to how, dependent on the number of owner unknown parcels. So this is the sum that was estimated to help us identify who might own those owner unknown parcels.
Okay. Article 12, and this Article 12, 13, and 14 are all linked together, and this has to do with the MBTA zoning proposal put forth by the Planning Board. And I'm going to give sort of a layman's Reader's Digest version of this, and then I'll ask Bob to get into more specifics. But we had, the MBTA article came up last spring. The crux of the article is that the state the governor, is requiring any towns that are served by the MBTA and adjacent communities to create zoning, to create housing in a particular district that encourages high-density zoning, relatively speaking. And it's a state mandate. It was imposed upon 171 communities. I think the number I got from Bob a little while ago, we were at like 118 communities have approved it. About 31, 32 have not approved it as of this point. We're at the point in our cycle on this where if we don't approve the MBTA zoning by the end of this year, we are not in compliance. So that's where we're at right now. There have been some changes to the rules and the law from last spring to now. It's a little clearer in terms of what the penalties are going to be and what the state is going to push back on us with, which is why this is brought back up again, is because there are changes. There are grants that we are no longer going to be eligible for. The state is imposing that restriction on several of the new grant programs. I think it's 14 at this
17
point.
total.
17 total grant programs that we are not eligible for if we don't endorse this. There is a court case now at the Supreme Judicial Court concerning the town of Milton, who also did not approve it, and the SJC has not yet ruled on the details of the court case with Milton, and once that happens, there'll be maybe some more clarity on what's going to happen from the state level. So, as I said, back in the spring, the article was rejected. It did not pass. We have it up now because there's new information that needs to be shared and some clearer definitions of what happens if we continue to not be compliant. And with that, I'll turn it over to Bob, and then Michael can have some info as well.
Sure. So Article 12 is actually the establishment of the district itself and the requirements for the district. Article 13 is the amendment to the zoning map to put on our zoning map the proposed district, and Article 14 is actually inclusion of the district on our table of use chart in our zoning bylaw. As you indicated, Mr. Moderator, the bylaw that you see here has been changed since the spring. There are some also changes in the law itself that occurred as recently as November, where 13 additional grant programs that were up to this point the subject of a Housing and Livable Communities Guideline have now been incorporated into the law by the Massachusetts Leads Act that was signed by the legislature and governor towards the end of November. So we now know that grant programs that the state agency added to the law are now part of the law itself. This article represents the culmination of a couple of years' worth of work and various tweaks over the years by the planning department to identify an area of the town where we could comply with the law by zoning an area that would have the least impact on the town. The planning department studied any number of areas of the town where this could potentially be located with impacts, and has discerned that this is the appropriate area for the town. And the planning department has determined that at full build-out, approximately 650 units could be built in this district, which stretches just westerly of the high school all the way through where the Bank of America is, and is set forth a few hundred feet back. As a practical matter, the planning department is also telling us that approximately 250 to 300 units are all that can practically be built because there is no infrastructure capable of supporting it, meaning sewer. If a developer was to purchase a parcel in that area and propose 15 units per acre, there's a possibility that someone could put a septic system in and develop something, but of the 40 or 42 parcels that are located in the district, all have been previously developed. So it would require someone to take down an existing business, because this is very much a business district, although there are some multifamily apartments. The 650 figure is actually a lesser number than what we would ordinarily be obligated to come up with, but because we have multifamily housing existing in this district already, we're not obligated to create as many units as the law technically requires us to create or zone for, because this doesn't require us to do actually anything at all other than to zone for it. So as
So
I,
if this were zoned, if I don't interrupt you, but if this were, if we did not adopt this zone and it were to happen elsewhere in town, would more units be required to be built?
yes, the town would be obligated to allow 1,183 units
Okay.
throughout the town.
I wasn't
in the
aware of
event
that.
this district is not selected. This district was selected to minimize the number of units that could actually be built, which is completely permissible under the law. And
Okay.
the town and the planning department have sought approval from the Attorney General for this draft bylaw and have received approval in advance. Remember, the bylaw itself doesn't require anything to be built. It only requires us to zone something for the hypothetical chance that it could be built. And there's been a lot of discussion online and around the community about the worst-case scenario. And the planning department has developed a very reasoned scenario that the worst-case scenario, which would mean every unit that exists out there today on those 40 parcels would have their buildings taken down, and a maximum of 650 units could be built. But, that would not be in one flush. That would be over a period of years because there are many, many owners. There's probably 35-plus owners for all these parcels. And not any of the owners have, at least to this point, come forth and said they're willing to sell and take their viable business entities and tear those down and construct multifamily housing. So the question you asked me is, where could this go? And it is my view that these 1,183 units could be located anywhere by a developer that was looking to convert an existing home into a multifamily, was willing to assemble some small homes that are close together, was willing to purchase some large property with acreage, or convert some commercial properties elsewhere other than in this district. And if we do not confine this to this particular district of the town, then the entire town faces the prospect of having multifamily housing developed in the villages and in the communities that surrounds this district. So, it's a real prospect. People are saying online that there's fear-mongering going on, and, the reality is there is a great deal of speculation about what's going to happen, because no one knows what the market will bear. But the reality is, it is a legal possibility here that if we don't zone for it, that we face the prospect of having somebody other than ourselves determine where this multifamily housing will be built. And I find that amongst all of the impacts that people are talking about to be the worst and the most injurious to the character and nature of the town.
Okay.
Mr. Moderator, I just want to add a couple of points to what Bob had said and what you had said. First, I wanted to ask one question. So, Bob, if town meeting was not to adopt this, and the December 31st deadline goes by, in January, someone could come in and build multifamily anywhere by right, is that correct?
Correct. Someone could propose, under the theory that we don't have a bylaw that complies with state law, and state law requires us to allow multifamily housing to a certain density and quantity, someone could propose, at the beginning of the year, to convert, as I said, to assemble and convert, and to purchase large properties or convert some commercial properties. All of that is a realistic scenario. And unlike projects where you need to get a special permit or a variance, when a project is allowed by right, which this law compels, the person that's applying for the permit can claim what they call grandfather protection as of the date of the application of the permit. So a subsequent change to the zoning bylaw that followed someone's proposed application to construct multifamily housing could conceivably not result in inability to proceed with the originally proposed project. There's no grandfather, well, they would be entitled to grandfather protection against the subsequent zoning change. And that's because it's by right and not by special permit.
Right now, it's by special permit. That's the change.
We do allow multifamily in some of our districts now with special permits.
Right.
But the change of the law is that it'll be by right with 15 units per acre density as of January 1st.
Okay.
Couple of things I wanted to mention. To Bob's point, you know, there is a lot of misinformation out there, and I really would ask folks to go up on the General Court website, take a look at Chapter 238, the Economic Bond Bill that was signed into law by the governor. That is the document that lists out all of the additional funding sources that if you're not in compliance with the MBTA zoning, you will not get the money. Now, in fact, Mike DeMayo got a $261,000 grant from the Seaport Council earlier this week, and they told him that if the town on the 16th votes not to support the MBTA zoning, that the town will not get that grant. But I want to direct folks to really go and take a look at that document, and you'll go through it. And for each of the sections, they've inserted wording that says, and provided further, that grants or other financial assistance in this item shall only be awarded to projects within municipalities that have been deemed in compliance or in interim compliance with multifamily zoning requirements in Section 3A of Chapter 48 of the General Laws, which is the MBTA zoning. And they've expanded. These are the subject matters that are covered: coastal assets, seawall funding, climate change, beach nourishment, mass development finance, brownfields, travel and tourism grants, mass works infrastructure grants, grants to rehabilitate, redevelop blighted, abandoned, vacant, or underutilized properties in municipalities, capital grant programs to promote and support large transformational projects to drive the economy, workforce development and higher education, Board of Library Commissioners, and Secretary of the Commonwealth Mass Historic Commission grants. So they've really broadened which grants that you need to be in compliance.
And that is all new information. That's why this is being brought up, because those were not in place when we had the discussion back in the spring about this article.
That is correct.
Right. So there's a lot of the...
Could I just also
Yeah.
add, people are concerned with what's going to happen. We've inquired and we've been told definitively by the Attorney General's office that effective on 1/1/25, January 1st, that the housing and livable communities will suspend our ability to obtain grant funds under the programs that Mr. Maresco just described. And they've also indicated that the Attorney General's office will bring an action to force us to zone an area. And it's not speculative that that's going to happen. It's basically what we've been told will happen.
Right.
And I have no reason to disbelieve them because they've already done that with the non-compliant community of Milton.
Right. So this is one of those articles where you really need to get informed. There's pretty vocal parties on both sides of the article. There are those who want us to tell the state that they can't tell us what to do, and then there are those who say, well, we need to have some structure in having us make the decisions about what's going to happen and not let the state make those decisions. This is one of those articles where you really need to go get informed, understand what you're voting on and what's coming up, so that when we're at town meeting, we can have a constructive discussion and figure out collectively what we're going to do going forward. So this will be a lively article, let's say, I'm sure. I'm not going to talk about 13 and 14 because they are all part of that MBTA article. They're just different pieces to it. So we're going to skip to Article 15. It says, will the town vote to amend the Marshfield Town Code Division 3 zoning bylaw, Chapter 305 zoning, Chapter 305, Article 6, special permit conditions for residential accessory apartments by deleting the current residential accessory apartment and replacing the current language and inserting new language about residential accessory dwellings. And then this is a planning board article, so it's a whole lot of information that's put forth. This is going to be Articles 15, 16, and 17 all deal with the same topic again. So we're going to group those together. But this is about residential accessory dwelling units, or ADUs. Who wants to take this?
I'll grab this.
Okay.
Earlier this summer, the state passed another law designed to create more affordable housing. It was Chapter 150 of the Acts of 2024, and it goes into effect on February 2nd, 2025. And it basically requires the town to have a conforming zoning bylaw that authorizes residential accessory dwelling units by right in any single-family residential district. The units can be restricted in size to not more than 900 square feet, but there are a number of restrictions that no longer apply. You can't require them to be owned, or you can't require them to be occupied by somebody that is related to the principal owner of the property. You're allowed to get them by right now instead of by special permit. Marshfield has traditionally allowed these things by special permit. They were supposed to be attached. They were intended to make single-family homes look like they continued to look like a single-family home. Now these can be attached or detached. The planning board has come up with a bylaw that authorizes them by right, subject to site plan approval with the planning board, which is basically a guarantee that you can build it on your single-family property, but you have to come up with a site plan and show the planning board that you're going to comply with the reasonable dimensional setbacks that we have in our bylaws for accessory buildings.
Right.
So Article 15 is the bylaw itself. We'll be deleting our existing residential accessory unit bylaw and supplanting it with this. Article 16 is a definition. It basically adopts the state definition of what an accessory dwelling unit is. And Article 17 is an insertion of accessory dwelling unit as a permissible accessory use in all of the residential zoning districts of the town.
Right. So I think euphemistically, the way this has been talked about as having an in-law suite, having perhaps a rental income coming out of a dwelling, an accessory dwelling on the property, and just facilitating making that happen to create some opportunities for additional housing situations.
Correct. And really the only limitation on them, other than their size and the setbacks, is they can't be used for short-term rentals.
Right.
I think Bob did a great job
Okay.
summarizing all of that.
So we're going to go forward to Article 18. Will the town vote to amend the Marshfield Town Code Division 3 zoning bylaw? I'm going to skip ahead just to the description of this. The language is to clarify when a proposed project requires a water resource protection district special permit. The planning board can also undertake the site plan approval in order to simplify and reduce the permitting by multiple boards. Bob?
Yeah, so this came up at the zoning board during the course of the last year, and there are projects where it wasn't clear whether the planning board or the zoning board was the special permit granting authority for some work that was done to alter some properties that were in the water resource protection district. And I can give you one example. Starbucks wanted to replace their sign. And ordinarily, that would be something that would be very simple to do with the zoning board of appeals. But because of the existing language, it had to go to the planning board. The planning board agrees with the zoning board that when you're dealing with something of that nature, and you're not dealing with a brand-new special permit, that's something that the zoning board should retain authority to approve.
Okay.
So this amendment allows properties that are already developed inside the water resource protection district, when they're making some minor modifications, to be permitted by the ZBA and not have to go through the full review of a special permit with the planning board.
Okay. That's pretty straightforward. Any comments, Michael?
No, I'm good, thank you.
Okay. So that's Articles 15, 16, and 17.
That's
Oh, no,
Article 18.
Article 18, we just talked about.
Correct.
Article 19 has to do with adding a new use of battery energy storage systems in the wholesale transportation and industrial sections of the table of use regulations. Again, this is a planning board article.
Yeah, I'd be happy to explain this, too.
Yeah, there you go.
So, as the world continues to evolve, it's become necessary for companies to store the power they generate, whether it's from coming off the grid and generated through traditional ways or from solar or wind power. And there's been a request on a number of occasions from Marshfield to allow a use called a battery energy storage system, which allows power to be stored in a battery facility so that when power is not needed, it can be stored and taken when needed to supplement demand. So this is, in the evolving world, this has become a need to have its own use.
Okay.
Because it's not always going to be attendant to a solar facility or something like that, but this is what's going on with Tesla and all the other companies that are storing energy, and it's basically to create a repository for energy, whether it's, you know, new technologies or old technologies that need to store the power.
Yep. And this is 19, 20, and 21. These three articles all deal with this battery storage article. So that's a
Correct.
planning board article.
Yeah, there's a definition of what it is, there's a location in the table of uses, and that's basically what we're left with 19 and 20.
Okay. 19, 20, and 21, isn't it?
No, 21 is a little differently. That's having to deal with a recent court case called Tracer 2, and our zoning bylaw as it related to ground-mounted photovoltaic installations was not compliant with that decision. So this is an amendment in Article 21 to bring our bylaw into compliance with the interpretation of Chapter 48, Section 3, as it relates to solar photovoltaic facilities.
Okay. I thought that was tied in with 19 and 20, but where
It's actually distinct.
where it's making ourselves consistent with bylaws that make sense. Article 22, basically there were two trucks that the DPW previously authorized, were previously authorized to buy for $90,000 for the two trucks, and that the trucks are not available, so they're reallocating the funds to purchase two different trucks. And that's a slightly increased price, correct, Michael?
That is correct.
So that's what it is. It's just, if anybody's tried to buy a vehicle lately, it's kind of an interesting little challenge to get what you need when you want it. Article 23, it's contract work to upgrade the Plymouth Avenue Pump Station. Again, this is a DPW article. Based on an increase in the scope of work and the need to increase contingency by approximately 4%, the total cost of the project is increased. So we're looking to increase the amount that was already authorized from $8.1 million to $9 million. Any comment?
And that is so. They've begun the work. That project's already happening. If anyone goes up Plymouth Ave, they'll see that they're doing the Plymouth Ave pump station. When they get in there, it was spec'd out to do certain things. They were replacing the tanks, the pumps, things like that. And they get in like any project on an older building, you know, the electrical conduit all had to be replaced and things like that. So it brought the price up. They've also gone after the state revolving fund for water projects, and they've been selected, and it's like a 0% for the first couple of years, and it goes to 2% for the life. But in order to do all of that, to finish the project, bond council recommended they go back to town meeting and have town meeting support the increase from 8.1 to $9 million, which is about a $900,000 increase for that project.
Okay. Do we need to rescind the original number and then reauthorize 900, or can we just add the 900,000?
I think we just
It's just an
modified.
authorization, actually, to increase the amount of borrowing.
Okay. But we don't have to rescind the original borrowing
No,
and do a
'cause we're-
different thing, just because of the funding mechanism.
Yeah, because all we're doing is increasing the amount of the borrowing.
Okay. Article 24,
I can talk to you about this one, too.
this is again, this is a Board of Public Works article about having the town purchase 829 Old Main Street extension for the purpose of water resource protection.
So, Mr. Moderator, this article is a request by the Board of Public Works to acquire a parcel of land at 829 Old Main Street, which if you're thinking about, if you know where ABC Equipment is, this property is located essentially across the street, and it's located at the corner of the driveway entering where one of our town wells is.
Yeah.
And there's an existing septic system there, and this property is now for sale. The Board of Public Works wishes to acquire this property for wellhead protection purposes. This price is a price that was equivalent to, I think, either our assessed or appraised value. We have this property under agreement, and the goal would be to acquire the property, raise the property, and prevent any further groundwater pollution from the septic system. And it is in Zone 1. It's within Zone 1. It's right next to our...
Yeah, it's right next to the station.
Correct.
I just want to add one thing, Bob, and this had come up, I believe the correct address, and we'll look this up before, to 829A Old Main Street.
Okay. Yeah, that would be a Scrivener's error if
Yeah,
there's
right.
anything anyways, but
I'll
we have this
double-check.
property under agreement.
Yep,
Okay.
thank you.
Article 26 is a Harbor Master article about mooring regulations and amending the language thereof.
Can we skip over 25, Mr. Moderator?
Did I?
Yes.
Yeah.
I skipped over 25. Oh, yeah. So this is a Public Works article looking to amend Chapter 285, Section 285-19.1 of the town's E-Code 360 bylaws by adding building commissioner to the list of town agencies that will receive notification of work plans.
So this is the bylaw that was enacted a few years back by, at the request of the Board of Public Works, that requires persons that are developing in Zone 1 or Zone 2 to notify the Board of Public Works what products they're using that might contain PFAS, and make an effort to proceed using materials that do not contain PFAS, or explain why you can't. And as a practical matter, the building commissioner was not included in the loop when notice was given, and as a result, there was no compliance with this provision. So the amendment requested by the Board of Public Works adds the building commissioner to the persons that are intended to receive this information, and that way we can guarantee that the building commissioner will not be issuing a permit without compliance with this bylaw.
Good. Do anything on that?
I agree 100%, yeah.
Article 26, will the town amend the Marshfield Town Code by striking information from the mooring regulations and adding new information. The explanation is the proposed change to the general bylaws updates existing bylaw language, eliminates the dates for annual applications or reapplication, and provides for an online renewal by mail or online. Speak
I
anything
think that's
to that?
exactly what it is.
Yeah.
It's
so-
updating the language to make the bylaws that relate to mooring renewals more friendly.
Article 27, will the town vote to amend Marshfield Town Code Division 2, General Bylaws, Chapter 34, Boating and Waterways, by striking the current language in paragraph C, K, and R that is identified in bold type and rewording these paragraphs as set forth. So again, it's amending language. The proposed changes are intended to update the language of certain provisions of the Waterways Bylaw to reflect more modern terminology, clarify regulations relative to tie-ups, and provide clarity as to restrictions of certain types of activities and uses that are restricted.
Yeah, so, generally what I was able to observe when I read this was that people, if you've been down to Woods Hole in the summer now, there are homes that are put on pontoons that are basically moored out in Woods Hole Harbor.
Yeah,
And
just make jokes about
to
those.
the average person, it looks like a shanty. Some people call that a houseboat. But this language is intended to apply to that as well. Houseboats and shanties of this nature are not allowed to be moored in our harbors.
Yeah.
So there's some new terminology there to make it clear what is not allowed.
Yeah. Yeah, we'd make jokes about that because you could have one of these crappy boats, houseboats, and anchor it off, and you've got the view of all those beautiful multi-million-dollar mansions, and they're looking at your crappy boat.
Right.
So, and the last article is Article 28, will the town vote to approve the amended South Shore Regional Vocational School District Regional Agreement, which is on file with the town clerk, or take any other action relative thereto? And basically, this is changing the formula that's used to calculate our charge from the South Shore Voc District for sending students there.
You're correct, Mr. Moderator. Superintendent Tom Hickey, I've invited him to town meeting. He'll be at town meeting. It's passed at already 6 of the 9 communities, and it's, as you said, it's changing the funding. They were doing a 3-year look back. Now they're going to do a 4-year rolling average, which makes sense because it's the kids normally go. It's a high school, so it's a 4-year. So they're making that change, and then it will be adjusted every 4 years on, because they'll look at attendance, and that gives them a good average of what the attendance is.
One thing I want to make, I had a discussion with somebody about this particular article, and they were saying that this should be is this going to be incorporated as a financial article? And it's not. We have already approved funding our students to attend South Shore Voc. That happened, I think, last year or the year before, that we approved enrolling Marshfield students as a member of the South Shore Voc community. There is another vote that's going to be coming up in January about funding a new school building for South Shore Voc, but as a completely different discussion that'll come up as a district vote.
It's a special district election that will take place in all 9 towns on January 25th, and I think the polls are open from 9 to 6. And that's where the project, the $276 million new South Shore Regional Technical Vocational School, will come before the voters to support it, a vote up and down like we would do for our projects.
Is that going to be voted on here? And each town has an
their own
election?
That is correct.
Okay.
Yeah, ballot question is the same for every community, but it's being held in every district that the vote tech serves.
Okay. So obviously there'll be more information on that, but there's no financial implication to this other than how they're calculating our assessment for being involved in that school. Okay. And that's the end of our warrant at this point in time. A couple of notes on town meeting itself. In the first, we had, at a recent town meeting, we had a surprising increase in the number of people that showed up at town meeting. And, typically we've got a very, modest turnout at special town meetings, and this was an extraordinary turnout. So we have, Mr. Maresco has set us up so that we have an overflow room. So the main room will be in the auditorium. The overflow room will be in the cafeteria. The cafeteria.
The gym.
Oh, the gym, I'm sorry.
Yep.
In my head, I was going to the gym. I just didn't say gym. So it's going to be in the gym, which is right across the hallway from the auditorium. The gym will be set up, and our main room will be set up so that we are linked with video and sound from both rooms. To make it easier for me to control the discussion, I'm going to have all of this discussion take place in the auditorium. So if you're in the gym and you want to come and speak, you need to come into the auditorium to speak. If we go to any standing votes, we'll make sure that there's enough time for everybody to get back to the gym and be there for taking votes in the gym. Don Gibson, our former moderator, has graciously offered to step up and serve as the moderator inside the gym, so we'll be all set with that. I think we're all set with having as many people as show up.
If I may, Mr. Moderator, we're actually set up to accommodate about 2,500 people. We'll have warrants, we'll have information for folks. I've rented the necessary equipment because we did not possess it, nor did the high school have it, for the rooms to be able to communicate, you to be able to communicate, people to be able to see in each of the rooms. So we've taken all the necessary steps. I'm a firm believer, people come to town meeting, they ought to be heard and be seen, so we've accommodated those folks.
Right. The first 4 articles, which are all financial articles, are going to be taken in order as we typically do at town meeting. After that, we go to lottery. I will be making a motion to advance that MBTA article to be the first article on after we go through the financial articles, because that's, I think, what most people are going to show up at that meeting to talk about is going to be the MBTA article, and there's no reason to put that later. I'd rather have everybody do it fresh and get that done. Town meeting starts at 7. I would suggest, in the last town meeting, we actually had to postpone it slightly until we could get the crowd all situated and such. I would suggest you get there early just to make sure that we can start on time at 7 o'clock. Where we have the overflow room, my intention is to start promptly at 7. So if you show up at 6:55 and it turns out it takes you 20 minutes to get into the room because there's a big line, I'm still going to be starting at 7. So I suggest you get there early. I think that's it from me. Anything from
Yeah,
you?
I just hope everybody comes and debates these articles, and it's the most important thing you can do is come and be present and be heard.
Yeah, it's a contact sport. You got to participate. If you don't participate, you can't complain about it later when it doesn't go the way you wanted it to. So make sure you show up.
Oh, we look forward to having everyone there. It's the purest form of democracy, so people can show up and be heard.
There you go. All right, everybody, thank you very much. Look forward to seeing you on Monday night.
Thank you.